and welcome to the session of Pro Lead Law and Management Academy. Today we are going to talk about very important topic that has been asked in your academic session exams and test papers. So you need to be very clear about this topic. Pay attention to each and every minute details. So first we are going to start about what is the difference between old criminal law and new criminal law. As a law student, you must be aware that now BNS, BNSS and BNA has been enforced and has been following by the law students, the practicing lawyers and the judges in our judiciary. So it is very important for you to understand what is the difference between old criminal law and a new criminal law. So in order to understand, we are going to start with the history. First, you need to understand about Thomas Babington Macaulay. Who was Thomas Babington Macaulay? Who was he? So in India, post-independence, there were laws, okay? There were personal laws, Hindu personal law, Muslim personal law, local customs law and religious. So what was happening was these laws were very consuming, time consuming. First, they were very confusing as well, very much time consuming. They were inconsistent, okay, because they were not mentioned anywhere, they were not written. So everybody used to follow as per their wish, as per their comfort level. So what happened was there was lot of confusion. So Britishers thought of enacting one unified law so that it becomes convenient, easy to apply, to enforce. So Britishers thought of calling Thomas Babington Macaulay to India. In year, note down, in year 1834, Thomas Babington Macaulay was called to do first legal reform and to upgrade the education system in India. So, in year 1834, the first draft of Indian Penal Code was drafted. However, it was not enforced, and it took 20 years. It got amended over the span of 20 years, and continuous amendment was happening. And after this continuous amendment, finally in year 1860, the IPC came into force, that is Indian Penal Code. Now you need to understand there are two types of law in India. First is substantive law, second is procedural law. So substantive law is what? Which tells you about the crime and its punishment. Procedural law is what? It talks about the trials, the procedure. So both were needed. So with Macaulay or by Macaulay, we got Indian Penal Code, which was a substantive law, which gave you a crime, type of crime, description of the crime along with the punishment. But there was a need again of the procedure of how to give the punishment, what span of punishment should be given, what should be the procedure. So procedural law was required, for which Criminal Procedure Code came into force. But who drafted Criminal Procedure Code? That is the question. So we will understand how CRPC came, who drafted the CRPC, and then we will understand about BNSS, BNA, BNS.